Pay for it?
Oh, just for me to approve it, which of course, you know, I will.
Okay. The other is Jesus Martinez.
All right, then, can you check outside to make sure it's working? And all right, everyone, I'm going to call the docket. Today is Thursday. And I know it is hot in the courtroom. I'm not in charge of the heat in the courtroom. The persons who are in charge of building maintenance is Commissioner's Court. So those are the people. If you have an issue with the seats are too hard, the benches outside for citizens who are coming for jury duty, if they're too hard, if the jury box benches are too hard, if the floors are not clean outside, you need to address that with Commissioner's Court. I have no control over that. So today is Thursday. It's going to be a great day. When I call the docket, please let me know you are here. In custody, we have Nicholas Gonzalez, Jason Lopez, Amethyst Garcia, John Ramos, Paul Donaldson, Rogelio Sanchez, Charles Garley. Thank you. Israel Elizondo, Brandon Cardona. In custody, we have Jorge Diaz. Mr. Mwandi Hamasi will not be brought over. Arthur Tovar. Ignacio Rios. Thank you. Jose Torres. Gerald Wickerson.
In custody.
Thank you. Daniel Bell. All right. Jason Flores. Jason Flores. Corwin Campbell. Thank you. All right. Have a seat. In custody, we have Michael Montoya, Sean Branch, Raymond Ruiz, Corey Hallett, Stephen Ward, Sam Wilson, Sam Wilson. In custody, we have Jesus Martinez Cantu, Joseph Anzaldúa, Corey Hallett is in custody, Richard Ruiz, Vernon Dixon, custody, Arthur Tovar, custody, Christian Segovia, custody, Ronald Rodriguez, custody, Jennifer Sutter. All right, thank you. Roger Villarreal. Jose Ruiz, that's an inmate. Brandon Guzman in custody. Theta Reyes, Sonya Hunt, and Desmond Fletcher custody. Is there anyone who came in late? I'm sorry, there's an add-on. Travis Molden.
I'm present for him as well. I'm here for Travis Molden, and I have a motion on file, and I'm also here for Sonya Hunt.
All right, thank you. All right, thank you. And then Zane Hernandez was for yesterday. I don't know why it's on the docket. And actually, I'm sorry, counsel, Travis Molden was for yesterday, but we'll see if it's on the docket today.
So I have it for next week, but I'll show up next week, and I'm here today.
All right. All right, is there anyone whose name was not called? Yes, sir. Jimmy Vasquez. Do you have an attorney?
No, ma'am. It's the first time I'm here.
All right, just have a seat. We'll get with you. Anyone else? Yes. I already addressed you. Thank you. Who are the people who are standing outside? It's not church. You can come in. What is your name?
Cara Clark.
Cara Clark.
Yes.
Are you on the docket today?
Yes, Judge. She's on the.
All right, you need to take a seat on the first row. Who are you, sir? All right, you need to take a seat on the first row. Is there anyone else who came in later? Your name was not called. All right, everyone, these are the rules of the court. I try to keep the courtroom as least congested as possible. We are going to be taking our break at exactly at 12 today because we have a jury trial that is currently in process. If your case is not settled, you're going to be called back, and it may be at time that's inconvenient to you. There are files on the left and files on the right. Once you pull your file, just place it on the prosecutor's desk, have a seat. First come, first serve. The only exception to that is if an interpreter is called down, because we have so few interpreters, they are allowed to go first so that they can get to other courtrooms. If you speak your client's language, an interpreter still will be needed for the record. Do not approach the court if you have not conferred with the state and conferred with your client. If your client is in custody, have the deputy bring them out. Do not approach the court if you have a client in custody and your client is not before the court. All right, everyone, put some patience in your pocket, be kind, confer.
Joe, Judge, I'm gonna need a translator for Mr. Martinez Cantu.
All right,
And it's gonna be brief because we have some other discovery issues we're working on.
all right.
As soon as they get them out, we're gonna be ready to go. Does your office keep protective orders? Well, if I'm signing one on the CPS records, I usually get them from either the DA's office.
Yes, the prosecutors will usually have those to print out, and then it's in our files.
Okay.
Oh, well, you'll have to let me know.
Shake my hands. He did.
I'll check up on it.
You look very, very busy. Could you tell me how many days Sonya Hunt had? She's second from the last on the docket.
$80.
89 days.
Then I would have got. Well, yeah, I do.
You'll come. You're in the docket, just got.
All right, Brandon Guzman.
Present, Judge.
All right, court is going to call 2019 CR 10921, State of Texas versus Brandon Guzman. Can I have parties announced for the record for the state
Jason Dorgans for the state.
defense?
Robert Mauer for defendant, Your Honor.
And are you Mr. Guzman? All right, the first thing on the docketing sheet that's set today, the state has requested the defendant's fingerprints.
Judge, I object. This case is almost 4 years old. I think the timeliness of this request is I don't find it relevant. I'd object and ask the court to deny the request.
Judge, we're not urging the motion at this time. I filed that as a matter of almost routine in case it becomes an issue in trial. Typically, we would need the defendant's fingerprints to connect him to any prior judgments, whether it's local or out of county history. But it could also be possible that he takes a stand and challenges the date of his arrest or circumstances of his arrest that we need to prove up for impeachment purposes. So we're not urging motion at this time. For that reason, we believe that the motion and the matter is not right for the court to rule on yet.
So you are withdrawing the court's hearing on this motion?
I'm sorry, Judge, we hadn't requested the hearing. We weren't aware that it was going to be set for hearing.
I mean, court sets motions.
Okay. We're not urging the motion this time, Judge.
All right,
I'll still keep my objection on file. Judge.
yes. All right, so that matter is settled.
And we still have our trial date, I think, next month. So
Yes, it's April 3rd.
I am ready.
Okay, is there anything else from either side?
No, ma'am, nothing.
And Mr. Mauer, have there been any issues? No clothing issues?
No, ma'am.
Okay,
No, we'll have it all taken care of.
all right. Thank you.
Thank you, Judge.
Thank you.
Sorry, Judge. Just so you know, I filed that motion for pretty much every case. I think I filed probably half a dozen in the last week.
So you need to let Ms. Ferguson know because
Okay.
the
Okay.
defense attorneys, they want hearings in those.
On the fingerprint motions? Okay.
Yes.
And I mean, during trial, I get that, but I try to get them
One
in
over.
advance of trial.
All right, thank you.
So you want me to hold on to
The fingerprint motions, we don't urge until trial, so.
Oh, I just keep it on file.
Yeah.
What do you-
Yeah, that's good. Thanks, buddy.
Yeah, so, is that okay?
No, that's fine. But it's on the fingerprint motions, even though I know sometimes they're considered pro forma. Sometimes defense attorneys actually want motions on those. And of course, if it's just, I'm proving up judgments for convictions, that's different. But if it's, I need this in order to connect somebody to an
Yeah.
offense, it needs to be heard.
The hearings would be like, Or
If the motions are, I mean, if the fingerprints are not just specifically for judgments, then we need to have a hearing on that.
right behind you.
So just let Caroline know.
Yeah, just
Sure.
let me know.
Yeah, I'll let you know if there's one that's not just.
Yeah.
Okay. All right, thanks.
All right, thank you.
Is there water? Yeah. So tell her. Yes.
So I'm ready.
Just 1 second. Let me call him back.
Yeah, sorry, I watched.
Hey, your interpreter, the interpreter's here. Okay, no problem. Thanks, bye-bye. He's just stepped outside to talk to the attorney's family, I mean, to his client's family.
Yes, right.
But whichever one, which case is that? All right, if you can give me that file.
Okay.
Thank you. And then Deputy Laura is Jesus Martinez Cantu. Can you have him brought out?
He's up there, you're awesome.
Oh, he is, okay. Thank you. All right, Jesus Martinez Cantu. All right. All right. Hello, hi, thanks for coming. So on this case, the last time we were here, there were CPS records. My understanding is that the state has those in their possession.
Yes, Your Honor.
Has the order been signed?
There was no spot for my signature, Judge, just.
No, it's just for me. All right, so the court has signed that, so you should be able to receive those.
They're making me a copy right now.
All right. If everyone could please whisper. Then we have child safe, and you need to make arrangements.
Yeah, I already talked to them. I'll make an appointment. They have those now. I'll make an appointment to go view them. And the last issue was phone dump records, and they're
Yes.
still waiting for those.
So state, when are you expecting the extraction on the cell phone?
Judge, we followed up on January 12th. We haven't gotten a concrete date yet. We'll follow up with the department again and figure out what's the soonest date they can get those to us. That's the only thing I believe is outstanding.
All right, so when will you have that information and update for the court?
We can probably have that update within 2 weeks, but if we can have 30 days, we may be able to have those records. I know they've been outstanding for a little bit now.
All right, so I'm going to give you a 30-day reset. This will be the last reset for cell phone extraction. If you see that you're not going to have that by that 30-day time period, that 30-day reset date that I give you is going to be a hearing, and witnesses will need to be subpoenaed to explain to the court why defense doesn't have these cell phone extractions.
Understood, Your Honor.
I need a 30-day reset. I need a 30-day reset.
I can do April 6th.
All right, so we're gonna come back on April 6th.
I'll be here, be in trouble with Guzman.
Yes, that's true. All right, is there anything else that's needed?
No, man.
All right, Mr. Martinez Cantu, do you understand the process?
Yes.
Right. And I will tell you, this is the second protective order that I've received on this case for for CPS records. The previous one that I signed was from January. So there may be an issue with communication. So make sure you get that today.
I will. I'm gonna wait for it, Judge.
All right, thank you.
Thank you. And Judge, the immigration lawyer is gonna give you the letter as well, the one you appointed.
All right, thank you.
Te puedes sentar para atrás donde estabas.
Theta Reyes. Thank you.
Your Honor.
You're welcome.
I didn't put the date on.
Oh, no problem.
Joseph Antandua.
Thank you, Your Honor.
Thank
May I
you.
be excused?
Yes, have a great one. It's always great seeing you.
Likewise, Your Honor.
All right, have a good one.
You too.
Who's here on Theta Reyes?
I am, Your Honor.
Yes.
All right, thank you. You're welcome. Where's your client?
She's in custody. They're bringing her.
Well, you're not ready to proceed if she's not out before the court.
No, we're asking, I was just hired. So I was asking for a continuance and I would request.
Your client needs to be out here.
Okay. I'll wait for it.
And Deputy Laura, I'm assuming they want Theta Reyes out here.
Yes, we're.
Thank you. You know, whenever we're not on the record, it's always quiet. And then when people come before the court, there's all the chatter. I don't understand that. Yes.
I think he took the file on that one because he was a couple months back for them to be over here. But then, I don't know, something, I don't think I case though.
Okay, I'm gonna text him and have him tell him to come to court.
Okay,
All right.
but it's in here.
All right, thank you.
Okay, give me one second.
Is this someone? Travis Molden. She calls it. Although that she retracted and said, no, I said yes. Either way. He's in custody for Friday night here today. I just want to make sure that he's going to be here Monday. And I'm expecting to come. That's what my calendar said. Somebody sign in for him. I love that. You can offer me money or should I give it to the other lawyer? He said, I said, give it to the other lawyer. I don't typically say that. That's the thing. So I'm not even telling you numbers. All right, thank you. I can work on 5. Yes. For somebody with eyes.
Martinez, Cantu. Sit you on this side. Second injection. Fletcher.
Good morning. See to see how much time in my client has. Let's see here, case number is 2018 CR 5306. Okay, perfect. Thank you so much.
Oh, thank you. Theta Reyes. Oh, are you conferring? Okay. All right, so everyone who's new to the court, these are the rules of the court. Do not approach the court unless you've conferred with your client, conferred with the state. Once you've done those things, if your client is in custody, please have them brought out and then approach the clerk. Tell the clerk to pull the file. The clerk will place the file up here and I will call you in the order of appearance. So please do not ask the clerk to pull your file if you have not conferred with the state and conferred with your clients. Thank you. Right. Theta Reyes. Hello.
Good morning, Your Honor.
Hi, your client needs to be in the center. How are you doing today?
I'm doing good, Your Honor.
All right. Are you from Bear County?
Yes, I am.
Oh, okay. Well, welcome to the 187.
Yeah, I've never actually had anything like that.
Oh, well, welcome.
Yes.
I think other attorneys will tell you it's not very frightening in here. Although nobody says anything when I said that, they're like, not gonna say anything.
I think it's the rules of the road thing. So once we learned them, then we're all good.
All right. All right, so where we were last time on this case, on February 27th, there was some agreement that was reached for a plea in misdemeanor court. And that's on cause number 2022 CR 2520.
Yeah, we had reached an agreement with prior counsel. This counsel was just retained and I believe he's asking for more time to look into the case and we'll leave the offer open one more setting, Your Honor, for him to
All
review.
right. Ms. Ferguson,
Yes.
on this case, bring it back in 2 weeks
Yeah,
for
could
plea
we do it a
deadline
month?
date.
Could it be a month?
No. I don't have cases sitting in this court for long periods of time.
Oh,
All right, Ms. Ferguson, 2-week reset.
The 23rd.
All right, so we're coming back on March 23rd. At that time, your client needs to let me know whether or not she's accepting the agreement. If she chooses not to accept the agreement, then the court will not consider any plea bargain agreements without good cause. Otherwise, she'll have to plea open to the court.
Okay.
All right, is there any citizenship issues or no?
No,
All right, thank you. Any questions?
thank you.
All right, thank you. And Ms. Ferguson, there's someone here by the name of Jimmy Vasquez, who believes he's on the docket today. And Brittany on this case. And Deputy Laura, could you mute us for just one moment, please?
Your Honor, may I approach?
Yes.
Your Honor, I represent Amasi. And can't pronounce the first name, anyway, the last name, Amasi. Anyway, she has been determined to be incompetent, and she's been ordered, Judge Carruthers Court ordered her to be restored.
And because of the nature of the case, it's inpatient treatment. So, Ms. Ferguson, can you give a 45-day reset on this, please? And make it a phantom date, so it'll be a phantom setting, because if she's being transferred, I would want them to not transfer because she has a court date.
Okay,
All right, so we'll put it down for April 17th.
April 17th.
Yes, and counsel, if you discover that she's been transferred, just come to the court and let us know.
Yeah, she's over at the mental. Yeah.
All right, thank you.
All right.
Ruben? I don't know if family violence, if both of those cases are yours or only one. So if you all can confer over that and see if there are any objections to the defense's requests. All right, thank you. Norma,
Yes, it doesn't have no.
that's fine. Thank you. The people who are coming in, if you're on the docket and you're late, you need to take a seat on the front row. Bashan, this next case that we're calling, there is no application. Court is calling 2023. Where's defense attorney on Sonya Hunt? All right, you are being blocked. Court is calling 2023 CR 0216, State of Texas versus Sonya Hunt. Can I have parties announced for the record for the state?
Ms. Evans, Debbie Cruz on behalf of the state, Your Honor.
I vote for peace on behalf of Sonya Hunt.
This Hunt, right in the center.
Ms. Hunt, do you need to have a chair?
No, ma'am.
All right, just one moment, please. All right, everyone, thank you for your patience. Counsel, have you received all the discovery in this case and did you review it with your client?
We have,
Court will find that the state is in compliance with discovery. Ms. Hunt, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
we waive.
State, are you proceeding on the indictment as presented?
Yes.
Ms. Hunt, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of theft under $2,500 enhanced?
Yes, ma'am.
All right, everyone in the box, you need to whisper. We're on the record. All right, did you understand that that's a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility
Yes,
and
ma'am.
up to a $10,000 fine.
Yes, ma'am.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you enter a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so, Your Honor.
Ms. Hunt, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the indictment as presented. They're asking that your punishment be assessed at 6 months in the state jail facility. There's a $0 fine, and they will take in consideration night mag number 689515. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That and credit for time served.
State, is that the plea?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No such motions, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State introduces state's exhibit number 1 and all of its attachments.
No objection.
And state, do you have the motion? All right, and state, I understand you have other attorneys to confer with, so you may be excused. You're welcome. Ms. Hunt, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney?
Yes, ma'am.
Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept it to evidence states exhibits 1 and attachments and review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, please.
Anything you wish to say on behalf of your client?
Ms. Hunt just had some mental health issues. She understands that she can't continue this way. She's getting up in age. And she's promising this court she'll behave when she gets out.
All right, what mental health issues are we speaking about?
Well, what I saw was that it said that she had mental illness. Would you like to tell the court?
This bipolar, schizophrenia, and depression, ma'am. That's what I got. And I had a real good drug problem. And I've been out there for a while. I feel better cleaning so I feel so much better. I feel so good right now.
All right, so what are your plans upon
When I get
release?
out, I would like to get I always wanted a GED. I always wanted a GED so bad. I want a GED and I want to stay out drugs and I want to get me a place, assisted living and enjoy my grandkids.
All right, so let me ask you this. How are you planning on doing that though?
Stay, I'm gonna get back in a good church. I'm gonna stay with my live with my sister. Doing all business and stuff, and I'm gonna go be around my grandbabies and stuff.
Is your sister in Bear County?
Oh, no, she's in Corpus Christi. But she works in Bexar County, she works in, she own a barber shop, she works here. And in my barber shop, she works in Corpus Christi, but she owns one in Corpus. And she works down here also as a barber.
All right, so here's my question. I want you to pay attention to my question. Because I'm trying to figure out when you're released from custody. All right, everyone, we're on the record. When you're released from custody, which the sheriffs, they're probably going to release you from the Bexar County Jail at 1 a.m. If you're released from there, if you have enough time in. If you do not have enough time in, they're probably going to transfer you to the state jail facility. How much time does she have in?
87 in, 6 months to do total.
All right, so you're going to be transferred to the state jail facility. When you get transferred to the state jail facility, they are supposed to work with you on a plan for what to do when you're released so that you just won't be released and have nowhere to go. So make sure that when you're in the state jail facility, that you follow through on the plan that they have set up for you. And that plan is supposed to be where you're going to live. That plan is supposed to be working with you on having skills for employment if you're able to work, and also addressing any mental health issue. You understand? That's yes or no?
Yes, ma'am.
All right. Court will find you guilty, sentence you to 6 months in the state jail facility, give you credit for any time served, taking into consideration night mag number 689515. Is there anything else with regards to sentencing?
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
I'm 56.
All right, so you're in the same boat that I am. We're in the twilight of our life. There's
You got
more.
all your teeth though. I ain't got no.
Hey, but you know what? As long as you can still chew your food, it's
I
good.
can't chew that word.
Oh my gosh. So you know what? They'll help you with dental as well. But here's the thing. You're getting to the point in your life where you need to ask yourself, do you want to spend the rest of your life in and out of prison, in and out of jail? If the answer to that question is no, then you're going to have to make changes. So when you go to the state jail facility, I want you to take this time to journal. Write down where you want to see your life. And you keep saying you want your GED, they can give you your GED at the state jail facility. Okay? All right,
I
good.
only wanted one.
All right, well, you need to do that. All right, good luck to you.
Yes, ma'am.
All right.
You got some pretty teeth.
Oh, well, thank you. All right, I'm gonna let my mom know that. She had a lot to do with that.
Thank you, Your Honor.
Thank you. I mean, that's just a beautiful day now. Jose Torres. And where's Mr. Torres? All right. Is that Mr. Cox? No, in the hallway outside.
I got your water. Oh, yeah, yeah. I'll explain that to you.
I mean, I don't think football season has started, but Mr. Cox is already pulling out the Gators hat. All right.
My brother was the other UT though.
You don't have a choice.
All right, so on so counsel, on Mr. Jose Torres today, the state was to make an offer and we were to see about discovery. So on January 19th, it said CPS records were needed. Where are we on the CPS records?
So we did submit a subpoena to CPS on the 19th, I believe, and we got a note on Monday, the 27th of February, requesting an extension to March 21st because they're very voluminous.
Okay,
So we don't have them, we haven't been able to review them.
so are they telling you that they'll have the records for you on March 21st? All right, so. All right, then the next thing is, has there been an appointment made to watch the forensic interview?
I have not done that yet, Judge.
All right, so the setting I'm gonna give you, that'll need to be done before the next setting. I'm
Yeah,
gonna
I
do.
understand.
All right, and then state, are you prepared to make an offer or no?
I can, we actually didn't discuss the offer because we talked about CPS records. But
All right, so I will reset it. And we're gonna reset it after the March 21st date. And when you all come back, you need to be prepared to make an offer on that date.
Understood, thank you.
All right, Ms. Ferguson, what date?
On it, on the 23rd of March, or do you want to give them a 30 days?
Give them 30 days.
Thank you.
I can come back on April 3rd.
Okay.
All right, April 3rd. Sign the reset form and then you're excused.
Thank you.
I'm just ready. This is- Before, like, when I took on the other part of it, already I- Somebody in the jail.
Oh, I'll address it after you talk to him. Oh, and Norma, don't forget about Mr. Jimmy Vasquez. Yes, he's in the red shirt. And state any update on the motions?
Yes.
All right, thank you.
Mr. Vasquez? Come up front, Mr. Vasquez.
And Norma, he's also saying he doesn't know who his attorney is or have an attorney.
I'll give him all that. Mr. Vasquez, come through there. You cannot come behind the. Thank you. What's your SID number, sir?
740-214.
Say it again, 740.
14.
You don't have court. Yeah, but you don't have court.
Because I have
You have not been invited. You haven't been invited on the felony case?
I don't think we're only gonna be indicted.
I was the state to be part.
Well, I was the one that's out there, so.
Okay, listen to what I'm saying. You gotta go to county court 7. You don't have a court date till March 30th on county court 7. Oh, you already know? So you don't have a court
I'm
date.
here for this work, not for coming to someone.
I'm telling you, you don't have a court date. today.
I'm telling you, but I have to show up here. So I'm telling you, I know I don't have a work day today.
But why do you have to show up?
Because my monitor, person that is on to the monitor, says I have to show up here. Can I talk to somebody about the
I'm
monitor?
recording. Have a seat and let me figure out what's going on. but monitor. Who's your pretrial service officer?
Mr. Bohat, he sends me a message every day, every time I need to come to court. And he sent me the message yesterday to come to court today. Want me to the phone?
No, I can call him. Have a seat and then let me call him. This will be a bad. Trying to help you.
Diana, thank you so much for those roles, 'cause they're so hard to find.
Morning, and I stopped there to get ice cream.
Mhm.
And I saw none had like four little.
Mhm. Yay. Okay, I'm excited.
I put them in the fridge in the shower.
Okay.
That's awesome. It is.
On the top.
Desmond Fletcher.
We're ready, Your Honor.
It's Caroline. On this one, I don't see the original, I just see the First Amendment. Sure. And I looked at the other one, it's from August, so I'm thinking. Oh, there's an issue when I see that coming out. Oh. That's a problem. Okay, all right, thank you. All right, court is calling 2018 CR 5306, State of Texas versus Desmond Fletcher. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
Andrew K. Hicks for the defense.
Are you Mr. Fletcher? Mr. Fletcher, I'm going to show you what's entitled motion to revoke community supervision and First Amendment motion to revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Desmond Fletcher who was placed on community supervision in 2018 CR 5306 for the offense of assault, family second offense on July 26, 2018 for a term of 5 years? Is that you?
Yes, ma'am.
State?
Your Honor, at this time, it does not appear that there is an agreement as to the motion to revoke.
Yes, but what are the allegations?
Oh, you're right, 1 second. Give me 1 second. Your Honor.
So off the record for a moment. So state defense, is there an agreement to please or true, or is this going to be contested?
It's going to be contested, Your Honor. We're in a, we're fine.
Everyone, please whisper.
We're fine with pleading true to the new number one because he actually was convicted of this already and he actually has done time served. We are just not in agreement as to the recommendation.
All right, so there's going to be a plea to the new number one.
Yes, Your Honor.
All right, so. All right, so we're back on the record. State if you proceed.
Yes, Your Honor. We say we'll be proceeding on violation of condition number 1 in that honor about the 11th day of June, 2022 in Galveston County, Texas. The defendant, Desmond Fletcher, committed the offense of possession of a controlled substance in violation of condition number 1. And the state would waive all remaining allegations.
All right, I'm trying to find that allegation in the motion that I have. Just 1 moment. All right, so I don't have a copy of the supplemental. Thank you, sorry.
I'm sorry, the First Amendment.
Wow, thank you, I do have that. All right, thank you. So to that allegation, how do you plead? True or not true?
True.
State,
Your Honor, the state waives the remaining allegations.
any objections to the state's waivers?
No objections, Your Honor.
All right, Mr. Fletcher, did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, and sentence you up to 5 years in the prison and up to a $500 fine? Did you understand? Knowing that, do you still wish to plead to try violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
There is not an agreement at this time.
State, what are you requesting?
Your Honor, the state's requesting revocation of the defendant's probation.
All right, and how much time are you asking for?
We'll be asking for recommending 3 years.
All right, defense, what are you requesting?
Your Honor, we're requesting 1 more shot at probation. If it would please the court, I can certainly ask Mr. Fletcher some questions on the record.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Desmond Fletcher.
All right, defense.
Now, Mr. Fletcher, is it true that you were convicted of an offense in Galveston County, Texas?
Yes.
Okay, why were you in Galveston County at that time?
Preparing my mother.
Okay, Mr. Fletcher, I understand that you are requesting 1 more shot at probation. Is that what I'm understanding?
Yes, sir.
Now, I understand that this is your second, this is your second MTR that we're here on. Is that correct?
Yes, sir.
Okay, and I also understand that you didn't finish a class that was required by probation the first time. Is that correct?
Yes, sir.
If given a shot at this again, would you complete this within the next 10 days?
Yes, sir.
Okay, or at least sign up for it within the next 10 days.
Yes, sir.
Okay, if you were given another shot at probation, would you leave Bear County?
No,
Even if another family emergency came up?
no,
Okay, would you be getting a job?
yes, sir.
Would you be submitting yourself to a probation regularly as required? Would you be paying down your fees? Okay. Mr. Fletcher, how long were you incarcerated in Galveston County?
Almost eight and a half, almost 9 months.
Okay, how much, do you know how much time you've been incarcerated here in Bear County?
What do you mean, this,
Here in Bear County, have you spent time behind bars here in Bear County? Do you know about how long you have?
yeah, probably about 5 months.
Okay. Have you done any reflecting while you've been in custody?
Yes, sir, and a lot of hard thinking and just,
Do you want to go to prison, Mr. Fletcher?
no, sir.
Or if you were given one more shot at probation, would you be successful?
Yes, sir.
I have no further questions.
State any questions?
Yes, Your Honor. Mr. Fletcher, isn't it true that on January 11th of 2021, you pled true to failing to report to probation on this case?
Yes,
And isn't it true that you failed to report for the month of January, July, August, September, October, November, and December of 2021?
yes, sir.
And isn't it also true that you also failed to report for the months of January, February, March, and April of 2022?
Yes, sir.
And those dates came after you pled true to the original motion to revoke, isn't that correct?
Yes, sir.
Isn't it also true that you submitted a positive urine sample for marijuana and cocaine on January 11th of 2021?
Yes, sir.
And isn't it also true that you failed to submit a urine sample on April 15th of 2021?
Yes, sir.
And isn't it true that you have failed to enroll in the Batter's Intervention and Prevention Program to this point?
No, sir.
You have not failed to report or failed to enroll.
I enrolled in the class. I went to it.
But you were kicked out of that program, isn't that correct?
Yes, sir.
And is it true that to date, you owe a balance of your total court fees in the amount of $4,244?
I'm not sure, but I guess so. Yes, sir.
And it's also true that you were convicted of possession of controlled substance out of Galveston County, Texas. Is that correct?
Yes, sir.
Okay, and in that case, what drug were you found to have possessed on that date? Or in that case?
It was cocaine.
Okay, the same drug that you tested positive for back in January of 2021.
Yes, sir.
How much were you in possession of in that case?
It was just a bag, more than anything in it, but they said less than a gram.
And you were convicted of that case, is that correct?
Yes, sir. I plead guilty.
I'm sorry. Yes, sir.
I plead guilty.
Nothing further, Your Honor.
All right, any redirect?
Ms. Fletcher, you mentioned to me that you would have a job waiting for you as soon as you are released. What job would you be working?
Sir, my place service. I'm a foreman of a construction company.
And how much money per hour would you be making?
$23 an hour.
And how many hours a week would you be working?
Over 40.
Do you have any skilled trades, Mr. Fletcher?
Yes, sir. I'm a carpenter by trade.
Thank you. No further questions.
All right. Has he done a trial court certification?
You know what? I don't believe so, Your Honor.
All right, if you could get a trial court certification, please.
May I go ahead and fill this out?
Yes. Do you
May we
need a
step-
pen?
Yes, please.
Deputy Laura, are you okay? Or are there still allergies?
Yes, Judge, I had pollen on my shirt. It has, I put my hands on the date.
Oh, no. Oh, and I checked the boxes.
Okay, thank you.
Yes. Thank you. All right, everyone, just give me one moment, please. Everyone, please remain in place. All right, is there any other argument from either side before the court makes its ruling?
And nothing from you, Your Honor.
All right. The court is going to, as previously stated, finding violation of condition number 1 true. The court is going to grant the motion, sentence you to 3 years in prison. There's an affirmative finding of family violence, give you credit for any time served. There's to be no contact with Sylvia Hill. Mr. Fletcher, I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Do you understand? All right, let's show you what's entitled trial court certification of defendant's rights to appeal. And because this is a felony conviction, because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand? If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Mr. Fletcher, I want to let you know that I did listen intently to your attorney's argument. I understand the issues that you're saying presented to the court, but I've given you chances before to try to do what needs to be done on probation, okay? All right, so good luck to you.
Thank you, Your Honor.
All
You may
right.
be excused.
Yes, thank you.
Thank you.
I don't know where this follows. Okay. Thank you. Jose, we're not ready on that yet. Yes, are you all ready or no? Sure, if you all will come up on Jose Ruiz.
Oh, no. Sorry.
All right, so we're here. There is the first issue is, Mr. Ruiz, you said you're going to hire an attorney. Are you hiring an attorney or no? Okay, so then you have your attorney appointed for you. Next issue is we were here on DNA comparison and the phone dump and SANE exam.
I believe, I think it was the other co-defendant. We had conferred with Todd McRae. All of that discovery has been squared away, other than
Okay,
that there is a cell phone, but it's one of those that we can't guarantee that we'll ever get into because it's protected.
all right. And so has an offer been tendered?
I don't believe so, no. And Therese just got on this case. So I don't even know if she's been able to review anything.
All right. So Ms. Ferguson,
Yes.
Mr. Ruiz, we're going to do a 30-day reset. And that 30-day reset, you all are going to need to confer off docket. So that 30-day reset, Mr. Ruiz, is going to be your pre-deadline date. This case has been going on for discovery issues since August. What date, Ms. Ferguson?
April 4th.
April when?
4th.
All right, April 4th is your plea deadline date. After that date, the court will not consider any plea bargain agreements in this case without good cause. Otherwise, you'll have to plea open to the court. Do you understand? I'm sorry. Oh, so here's the way it works in this court. The state is required to make an offer in their cases. Their offer is their offer. I don't interfere with any offers that are being made because those offers are confidential. Once the state tenders the offer to your attorney will tender that offer to you. Then you all will let the court know whether or not you're accepting the state's offer or not. So I'm telling the state that they're going to confer off docket, so they're not conferring in the courtroom. And on April 4th, we're going to come to court. And on April 4th, you're going to let me know whether or not the offer that the state has extended to you is accepted or not. If you decide to accept the offer, then the court will make a decision on whether or not she'll accept your plea agreement. If you decide not to accept the state's offer, you say, I'm not accepting this offer, then the court is not going to consider any further plea agreements between you or the state unless there's a good reason or good cause for me to do so. Otherwise, what will end up happening if you want to enter a plea, you'll have to plea open to the court, in which case you'll be subject to the full range of punishment or subject to probation if you're eligible for probation. Not saying that I will give probation, not saying what time I will give. I'm just speaking generally. All right, so do you understand what I mean now? All right, all right. You're welcome. And if ever there's something you don't understand, let the court know. I believe communication is key. All right, so we'll be back on April 4th.
Your Honor, if I may, the victim in this case is deceased.
Mhm.
I've spoken with various members of the state, not so much Mrs. Mitchell, but other people who were involved before. It's my understanding they're considering a capital murder charge, possibly a murder charge. They have not made a final decision on that. But I would ask that I be permitted to have Lorraine Efron as my second chair, since she was on the case from the beginning. And she assured me she knows what's going on and the various procedures.
All right, where's this case from?
At this time, Your Honor, barring any new evidence that might come to light at this time, we're proceeding as it is alleged. However, we certainly don't object.
Well, I mean, if I appoint someone, I'll appoint someone without state input. But let's see where we are on April 4th. And depending on where we are on April 4th, then the court may do that.
But not yet.
Not yet.
Thank you.
All right, you're welcome.
Excuse.
Yes.
Thank you.
Come on, Reese.
Who's here on Amethyst Garcia?
Good morning, Your Honor.
Good morning. All right, so we have two cases with Miss Garcia.
Yes, Your Honor. Has Your Honor had the chance to read the PSI?
Oh, yes.
Oh,
And I'm just making sure on the motion to revoke, I don't think any pleas were entered.
no, Your Honor.
And state, are you going to proceed with the motion to revoke as well?
Yes, Your Honor.
All right, so we'll start with the motion to revoke for her to enter whatever plea she wants to enter.
Yes, Your Honor.
And Diane, I'm going to call both cases at the same time. Court is calling 2021 CR 2958 and 2022 CR 8569, State of Texas versus Amethyst Garcia. Can I have parties announced for the record for the state?
Go ahead, Your Honor.
And are you Miss Garcia?
Yes, ma'am.
Ms. Garcia, in cause number 2022 CR 8569, you entered a plea, and according to the plea bargain agreement, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,500 fine. State is silent on your application. They're taking in consideration NIMAG number 688702. Have both parties had a chance to review the PSI report?
Yes, Your Honor. With my understanding that the cap was at 4 on that sentence.
No, I'm just reading what's in the,
My understanding is cap at 5.
5.
yes.
Okay.
All right, have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense? Any objections to the PSI report, state?
No objection, Your Honor.
Defense? All right. And then Ms. Garcia, I'm going to show you what's entitled motion to revoke community supervision and state's motion to supplement pending motion to revoke probation. Did you review those documents with your attorney? Did you understand them? I can't hear you.
Yes, ma'am.
Are you the same Amethyst P. Garcia who's placed on community supervision in 2021 CR 2958 for the offense of possession of a controlled substance, penalty group 1 gram or 4 grams on April 18, 2022 for a term of 5 years?
Yes, ma'am.
All right. State.
Yes, Your Honor. Actually, Your Honor, on violation condition number 1, for the June 9th, 2022, the state would like to orderly amend it, striking the language W/IDEL, which stands for with intent to deliver. to the court.
Any objection?
No objection, ma'am.
All right. Ms. Garcia, do you understand your attorney has 10 days to prepare for trial? Did you understand that's a substantive change to the motion to revoke?
Yes,
Knowing that, do you still wish to continue?
yes.
Thank you. All right, we've lost video. Okay. All right, State?
Yes, Your Honor. Violated condition number 1 on or about the 9th day of June 2022 in Bexar County, Texas. The defendant Amethyst P. Garcia committed the offense of possession of controlled substance, penalty group 1, 4 to 200 grams. In violation of condition number 1.
How do you plead to that? True or not true?
Your Honor, we'll waive the remaining violated conditions.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. I'm assuming there is no agreement on the motion to revoke.
That is correct, Your Honor.
All right, and the state is silent on 2022 CR 8569. And that cause number defense, do you have any witnesses?
Oh, yeah.
All right, then the court will hear argument.
Well, on the, are you saying for the application for probation?
Yes.
Yeah, the application for probation. Now, when we were trying to negotiate all of this MTR and everything, so my understanding is, and of course, right now I'm saying it's different, but my understanding is that the MTR agreement for the for punishment would be to run concurrent or to run together with the case that she plead on. So that's what, on that new case, Your Honor, we're asking this court to give her another opportunity. Now, she did not comply with her probation. In fact, she, as Your Honor can read, she didn't even start her probation. She didn't show up for orientation or anything like that, which caused the warrant and everything to come in. Now, she's realized she's been in jail since November of 2022. She realizes that this has to stop. And she picked up a new case. It doesn't get any better, Judge, it gets worse as you go along. However, I'm asking this court to give her another opportunity. And why should you give her another opportunity on probation is because I think that she realizes that this has to stop. She had a death in the family of her grandmother last year. That was her mother figure. She lost a brother who also contributed to her mental state, which made her do bad judgment. So we're asking the court to give her the opportunity to go on probation, do things right, go back, because she's got 5 daughters to go home to, which are in the hands of their family. She has a father that is there, that is willing to support her, and she also has a job that's waiting for her when she gets out. So we're asking the court to give her the opportunity. It's a second opportunity. I know that the facts in her case don't warrant it, but we're asking the court to do so. Because I had long conversations with Ms. Garcia, and I can tell the difference in attitude as to what she has to do in order to continue on with her life. Now, the TAP evaluations are recommending safety, and safety right now is, I know it's a long waiting list, and it'll be maybe a year, a few months before she goes to safety. But we're asking the court to follow the other alternative, which is the outpatient treatment, and put as many requirements on her for her probation to do the outpatient treatment. That way she can go to work, she can go take care of her children, and she can prove to this court that she, and I'm not saying she learned her lesson, I'm just saying she had learned that she has to stop. That's the only words I can come up with. She has to stop. She has to grow up and be there, a parent for her children. And I'm asking the court for probation.
All right. So anything you wish to say, Ms. Garcia?
That I shouldn't have used it, is it?
All right, do you want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. You're gonna have to make sure you keep your voice up. State your name for the record.
Amethyst Garcia,
All right, what would you like to say?
that I apologize that I was in the wrong, that I used an excuse when it's not an excuse, and I've acknowledged that now. I'm not saying that, oh, no, that's the time. No, I know that I have to do what I need to, and I do have 5 daughters, 9, 8, 7, 6, and 5. And I need to be there for them. I do have a job lined up. I do have support from family, and it's time to go on with my life and to carry on and do what I need to do as a woman, as a mother, and do what I need to do.
All right. Ms. Garcia, I'm looking at your criminal history. And sometimes people are learning their lessons, you know, but your criminal history is not good. And when I look at criminal history, I'm not necessarily looking at it to say, oh, this person is a bad person. I'm looking at it to see, has there been any type of intervention? Has somebody learned their lesson? Is there anything that I can do to protect the community and have this person being, you know, productive member of society? And I'm looking at your history, and there have been plenty of interventions for you, and you have not taken advantage of any of those interventions. And I don't think probation is appropriate for you because of that. And because of other things that are in the PSI report, the fact that I previously had you on probation to work with you. And I think any defense attorney in this courthouse, in this courtroom will tell you that when I put people on probation, I'm hoping that they will be successful, and I give them conditions to have tools to be successful. And I always ask people when I place them on probation, I always ask them, is there anything else they need from the court to be successful? And what you've done since you've been on probation is not report, you just picked up new charges. And I can't have that. All right, the court is going to sentence you to a $1,500 fine, time and money. I'm sorry, cause number 2022 CR 8569. The court will sentence you to a $1,500 fine, time and money, and run concurrent. This will run concurrent with 2021 CR 2958. 5 years in the prison. Take in consideration night mag number 688702. Give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Because this is a plea bargain agreement, because I followed your plea bargain agreement and you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Now, if you would like, because I do see the TAP evaluation, they're recommending that you do inpatient treatment. If you would like, I could recommend you for the therapeutic community. It is a drug treatment program. I cannot force them to put you into it. All I can do is recommend it, and then you will have to recommend it yourself. It does not increase the amount of time that you're in custody. Would you like to be considered?
No. We're being in custody. Don't do it. Would you explain again, Your Honor?
All right. So the therapeutic community, I do not have jurisdiction to force them to place you in the therapeutic community. The therapeutic community is a program at the prison that will hopefully help you with any drug issues you have. If you're accepted into the therapeutic community, it does not increase your prison time. So for example, in this case, you've been sentenced to 5 years prison. If you're in the therapeutic community and you do not complete it, they're not going to say, oh, she didn't complete it in 5 years, so we're giving her 6 years. if you're up for parole and they deem your parole worthy at 2 years, they're not going to say, we're giving her parole. We would give her parole, but because she hasn't completed the therapeutic community, we're not giving her parole. So it's merely a program to help you, hopefully, with any drug issues you have. All right, and we'll do a request for therapeutic community. All right, next we're going to move on and cause number 2021 CR 2958. The court found violation of condition number 1 true. The court will sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 8569. There's to be no contact with Antonio Ruiz, Reyes. And there is a $1,500 fine, time and money to run concurrent. And that cause number I'm showing you, and I'll request the therapeutic community. And that cause number is showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? I'm sorry?
Yes.
All right, this has not been a plea bargain agreement, so you do have a limited right to appeal. And that right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Do you understand?
Yes, ma'am.
All right, and because that is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, again, you'll need to speak to your attorney. Do you understand?
Yes.
All right, we can go off the record. Ms. Garcia, I know you wanted probation. Your attorney told me about your daughters. When you get out of prison, you need to make sure that you stay on the straight and narrow so you can be in their lives, all right? All right, good luck to you. Charles Garley. Hello.
Morning.
Hello. And so there were issues with discovery. Have you guys, that's been turned over to me?
So Judge, we both looked into it. I reached out to the city attorney who turned in the discovery for the in-camera review. He said that that was the correct IA case number, that it may have been a typo on the letter that the defendant received. Both of us called internal affairs. Mario got it more information than I did, because he probably stayed on the phone for a lot longer.
So the records the court reviewed are the correct records.
Right.
That's our understanding. Your Honor.
And so there's no, we're gonna go on the record.
Yes, Your
Court is calling 2021 CR 7282 State of Texas versus Charles Garley. Now parties announced for the record for the state.
Daniel Escobar for the state of Texas.
Mario Moreno for the defendant.
And are you Mr. Garley?
Yes.
All right, so we're here because there were some issues on whether or not the court received all of the documentation to review for in-camera inspection. So state in defense, are you telling the court that the documentation that the court received was the entirety of the AI documentation?
As far as both sides are aware, again, we reached out to the city attorney. He confirmed that those are the documents he had in his possession, and that the IA case number that the defense provided was incorrect and went to another case. Both parties called internal affairs, and we got more information that helped us determine that that should have been everything.
That's correct, Your Honor. Mr. Escobar did reach out to internal affairs and spoke with the sergeant there and learned, I guess, some clarification on what was going on with those records, and there was a clerical typo on the case numbers. I reached out to that same sergeant the next day, and he confirmed, and I spoke with him a little bit further, and he confirmed and clarified what the issues were in regards to the differences between what we received in that letter with Mr. Garley that we presented to the court, and with what was presented to the court for that in-camera review. All of that was clarified and we determined from the parties that everything that was turned over and what that was given to the court was the full picture.
All right, so most importantly, defense, are you satisfied with the explanation and you believe that the court has received all of the IA documentation?
Yes, Your Honor.
All right, and the court reviewed the IA documentation. The court turned over to both the state and the defense what the court believes the defense is entitled to based upon the review of the IA documentation. And the court will tell both parties a majority of the AI documents that the court reviewed are discoverable issues that the defense should already be in receipt of, body cameras, that type of thing. All right, so state that you tender an offer,
Yes, Judge.
and when was that tendered?
It was tendered previously, but I did confirm to the defense that that was still the offer.
All right, and so is that offer being rejected? Because we've been here before.
No, Your Honor, I spoke further with Mr. Garley now that we have clarified and cleared up any issues with that IA investigation. Mr. Garley has informed me that he is wanting to accept the offer from the state.
Okay.
However, he is requesting, and I spoke with Mr. Escobar about this as well, if we could come back tomorrow morning to complete that plea. Mr. Garley, family man, you know, he's having some children. He has a newborn child and one almost on the way. And he's wanting to have discussions with his fiance and have a sit down and explain. This has been a long drawn out process, as the court has explained, Mr. Garley.
I mean, he's an adult.
I understand, but again, a family man as well. Just make sure that everybody, I mean, you know, he has to not only think about himself, but his family.
All
He
right,
just wants to make sure that everybody is on the same page, but he will come back tomorrow.
all right, if you want to step out in the hallway and call them, you're more than welcome to do so. Because this case has been going on since 2021. We're now in 2023. And I understand there were some discovery issues, but if he wants to step out in the hallway, he can. Okay, all right, thank you. Vernon Dixon,
He's downstairs, Robin.
all right. On Mr. Dixon, can you let him know that his attorney is in trial and impact court? So Ms. Ferguson, can I have a 2-week reset on Mr. Dixon?
I can do it for the 21st March.
All right, State Dixon, that will still be a discovery and it'll be on March 21st.
March 21st.
Yes. Who's here on K Johnson? Yes.
It's off docket. I've discussed it with the stands. Ms. Johnson is on law right now. She's been on law for about a month. She feels the need to go into inpatient treatment. She set that up. She can start Friday.
All right.
Just asking the court for permission to do that.
She wants to go into inpatient treatment and it's not an indicted case.
Judge, the state wasn't gonna oppose, we're just gonna go to the court and see what type of bond conditions you wanted to put to make sure she stayed there. But that's what she was going to do.
I mean, it's voluntary, judge. If for some reason it doesn't work out.
Yes, I mean, the previous conditions still remain. But yes, she can go to rehab.
Thank you, Judge.
Sure.
Thanks, Judge.
Thank you. All right, is it just me or is it hot in here?
It's hot in here, Judge.
Could somebody please call Commissioners Court who are in charge of the AC? That the AC is not working.
Well, I've been to the 10th floor. It works fine up there, Judge.
It does, and you know, they had an expansion of their offices, but my understanding is on the civil side, they have an infestation of raccoons.
Okay.
And it's not the raccoons from the cartoons where you like, oh, they're so cute and fluffy.
Raccoons are interesting.
All right, and then we have the sewage smell.
Yeah.
So hopefully, they said they didn't know about that, but I let them know there's a sewage smell.
I have another off docket matter that was attached to this. I don't know if you got that one. I'm pressed.
Just give me one moment. Rogelio Sanchez. Hello.
Hello.
All right, so what we're here today is, and we're supposed to be here tomorrow instead of today, but I know it got moved because we're doing different things on Fridays, but the state was supposed to make an offer.
I guess I was misinformed, Judge, because
Okay.
I remember that I was supposed to I thought I was supposed to determine whether we were seeking to death or not. And
Okay,
I do apologize that I
No problem.
misinformed myself. So,
Okay,
because I
no,
was here and I that's what I remember, but obviously I know you write it all down, so.
yeah, but no, on, and maybe because they're new prosecutors, but I have on October 17th, the state said they were not seeking the death penalty.
That is correct. And that's why I even called the previous prosecutor and made sure about all that. Because it wasn't notated in our file, but the last time I thought that Mr. Cox had mentioned to me that, to determine that, I was like, okay.
Okay.
I determined this.
Yes.
I did talk to Mr. Cox and Ms. Garza this morning, but I did talk to Mr. Cox that I will be getting an offer to him. I haven't been able to talk to some admin that I needed to talk to, Judge. I said I'd probably do that today, tomorrow.
So how much time are you requesting state?
I told him I could I should be able to get to him early next week. So if 1 week or 2 weeks,
All right, do you want to put this at the beginning of April or the end of March? And is that enough time for everyone?
beginning of April is fine with me, Judge.
Fine, Your Honor.
Okay.
Because a lot of times, Bridget, I'm noticing that people will stand before me and they will say, oh, I can do that tomorrow. I'm like, just give it to me straight. Yeah, straight, no chaser, right?
Sorry, Judge.
That's okay. Ms. Ferguson? All right, so is April 3rd enough time for everybody?
Yes, Judge.
So April 3rd, state is to make an offer. And then council, once the state makes the offer, Mr. Sanchez, it's going to be a quick turnaround for a plea deadline date. All right, is there anything else, any discovery issues?
Not at this time, Your Honor. I'll double check what we have.
Okay.
Make sure.
And just to let you know, I did receive all your motions.
Okay, I'll file some more.
All right, and
We'll get.
with regard, as you both know, because you've been in here before, with regards to motions, if it's motions that you all can agree on, then let the court know what you're agreed to. If it's something you can't agree on, we'll set it and just get a date from Ms. Ferguson for that.
Most of them are just the normal, like witness listings, like that, or so.
Okay, all right, thank you.
Thank you. Sorry.
Not here.
All right, Paul Donaldson, can you let him know we're coming back on March 6th? And Ms. Ferguson, is that attorney in Del Rio on a federal case? Okay,
Confirm that.
all right, thank you.
Can you
Oh, sure.
appreciate that?
And Deputy Laura on Michael Montoya, state on Michael Montoya, that's being reset also for March 6th, attorneys in federal court.
March 5th.
6.
Six.
Yes.
Okay. I was like, I was looking for all those, that's all those. Great on. Thank you, good.
You're welcome.
And Judge, does that mean also that,
That looks like if that was Matheral and the attorney, would that also be on Paul Donaldson? then?
Yes,
Okay.
and that would also be March 6th?
yes. And also Ignacio Rios.
He's not on bond, Judge.
Ignacio Rios, where are you? Come forward, please. All right, Mr. Rios, your attorney is actually in federal court, which takes precedent over state court in Del Rio. So we're going to recall your case for March 6th. So they'll give you a reset form and then your excuse. All right, thank you for your patience. And thanks for dressing appropriately for court. Raymond Ruiz.
Ruiz?
All right, are we here for a bond issue?
I'm gonna ask the court to set a bond on that case and also for, it's a plea deadline, Your Honor.
All right, have you conferred with the state on the bond?
Yes, but we haven't agreed on an amount, Your Honor.
All right, so before we go on the record. So the court shows that all discovery was received, and today is your plea deadline date, Mr. Ruiz. So
We haven't, it's gonna be set for trial, Your Honor.
all right, so you're Mr. Ruiz, you're looking at me very quizzical. Do you understand what's happening here? All right, so the court ordered a plea deadline date for today, which means that the state had tendered an offer. So are you rejecting the state's offer?
No.
Are you requesting a jury trial? All right, state, do you know which case you'll be proceeding on first?
Judge, I only represent him on that 7156, I think.
7154, Judge, and I think
54.
that's, assuming that we have the witnesses, that's the one we would proceed.
Okay. And who is the attorney on the other matters?
It's Mr. Davidson,
Okay.
Bill Davidson. He only hired Corpa on one case. And Mr. Davidson was appointed.
All right, so with regards to the offer that was extended in the 7154, was that offer to encompass all cases, state?
I would assume so, Judge. It didn't really, oh yes, it did specify take care of all of the cases, so yes, that would encompass all cases.
All right. So, and that clause number, I'm gonna need an acknowledgement of discovery. And then, how long are you all expecting the jury trial to last in this case?
If we get to the guilty and get to punishment, Judge, maybe about a week, we can have. There's a lot of punishment at least.
Okay, Ms. Ferguson,
Yes, sir.
Mr. Ruiz, I need a jury trial setting. And can you make it a day when we have impact available?
And that would be April 3rd.
All right, April 3rd
Yeah, Judge.
is your jury trial date. The court will not accept any plea bargain agreements in this case without good cause. Mr. Ruiz, the court will not accept any plea bargain agreements in this case after today without good cause. Otherwise, you have to plea open to the court. Your jury trial, they're gonna bring you over dressed for trial on April 3rd. They will bring you over dressed for trial in whatever clothing you have at the jail. If you wish to be attired in something different, you'll need to sign a clothing exchange for your attorney. Counsel, if there's an issue with the clothing exchange, just let the court know.
Thank you, Judge. And also on the bond, Your Honor, can we have a bond set?
Oh, we can have a hearing on that. And what is the bond currently set at?
I think it's remaining.
it's remanded without bond, but he had a 40,000 before. I was asked the court if they could just double that one.
All right, so State, are you ready to proceed on the motion to set bond?
Yes, Your Honor.
Court is calling 2022 CR 7154, State of Texas versus Raymond Ruiz. Can I have parties announced for the record for the state?
Jason Morgan, Service State.
Defense?
Nomado representing Mr. Ruiz.
All right, and are you Mr. Ruiz? Defense, you filed a motion to set bond. Do you have any witnesses?
Just, just ask the court to consider the case there, but I can ask the defendant on
I mean,
questions.
it's
on the bond.
completely up to both parties if you have witnesses or not.
Yeah,
The
well,
rules of
just-
evidence do apply in
I don't have any
bond
witnesses.
cases
Where
where the person is remanded without bond.
well, I have one witness. I can bring her in right now, Judge.
All right, if you have a witness you would like to call, the court is here to hear witnesses.
Mr. Reese, on this status.
And then after this case, it will be Campbell. I have a Preston, Elizondo, Bell. All right, if you come forward. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record, please.
Elizabeth Mateos.
All right, defense?
May I proceed, Your Honor?
Yes.
Ms. Mateos, do you know Raymond Ruiz Jr.?
Yes, I do.
Do you, how are you related to him?
He's, my boyfriend.
You know, he's remanded without bond in this case.
Yes.
You're asking the court to set a bond?
Yeah.
Okay, and where do you work?
Provider for group homes.
Okay, and how much do you make a week? Okay, and you have expenses yourself?
Yes.
Okay, and how much do you make, how much do you have in expenses a week? Yeah, you're almost breaking even.
Yes.
Let me ask you, you're asking the court to set a reasonable bond in this case.
Yes.
How would you're asking also the court to set a bond at least 40 to 80,000? Okay, how much of a bond can you afford in this case?
I don't know.
But you're still, will be trying to
Yes.
bond them out as your bond is set.
Yes.
And no further questions done.
All right, any questions?
Yes, Your Honor.
State?
So is it Ms. Mateos?
Yes.
Ma'am, so I guess you're the victim in an incident from October of last year, right? Or you're the alleged victim from that case?
Yes.
You understand? I'm sorry?
I'm sorry. There was an affidavit that I.
Yes, so you filed an affidavit of non-prosecution,
Right.
basically saying that it didn't happen, right?
No, yes.
Okay. But you understand that case was filed, that you're listed as the victim for the case.
Yes,
from
I just
October.
found that out.
So this lady right over here, she's got to take down everything that's being said. So if I'm asking a question, if you can just let me finish asking the question,
Okay.
and I'll try to do the same for you. Now, you understand that the case we're here for today, that they're asking for a bond to be set for, that's not the same case that you were listed as a victim for.
That's correct.
Okay. Are you aware of the other cases that Mr. Ruiz is charged with?
Yes, listen.
Okay, what do you think he's charged with?
Assault with a deadly weapon.
I'm so sorry. Can you make sure you speak up so I can hear?
I think it's assault with a deadly weapon.
Oh, and that's the one that we're here for today?
Yes.
For the bond hearing? Are you aware that he's actually been charged with those kinds of cases before?
Excuse me, I'm sorry.
Are you aware that he's been charged with those kinds of cases before?
Yes, sir.
Did he tell you about those?
Yes.
And he's actually been convicted and gone to prison for them before, right?
I don't know.
Now, on the date that this happened, I guess you talked with a constable, right? Was it Deputy Sanchez? Does that sound familiar?
I don't know what the names.
Okay, maybe you talked to some police officers.
It was at a convenience store.
Okay, and you talked to the officer on that day?
Yes.
And you understand the importance of telling the truth to the police,
Yes,
right?
yes.
Do you have any children?
Yes, it is.
What children do you have?
I have a 12-year-old.
And are you concerned for your children? It's a 12-year-old son, right?
Yes, no, no.
Okay.
They have a real good relationship.
I'm sorry, I couldn't understand what you were saying, that last part. What did you say?
They have a real good relationship, my son and Mr. Ruiz.
And I mean, that's not really what you convey to the officers, right?
What I read from the report, it doesn't sound like anything that I said that day. I do none of it, as of the same thing that what happened that day.
Okay. So when you said Mr. Ruiz had threatened to kill you and your son, that is not true.
No.
Okay. And-
All right, and I'm sorry, just for a moment. If this witness is going to deny what she's told the police, she'll probably need to have an attorney appointed to represent her. So is that your intent, to deny what's in the police report?
Yes.
All right. You want to ask another question of this witness?
We'll pass the question.
All right, any other questions?
I don't know further questions, yeah.
All right, may I ask one question? Is there any objection? How long have you known Mr. Ruiz?
I've known maybe about 10 years.
All right. And you say that you are a home health care provider?
Yes.
And are these persons that you take care of in your home?
No,
Or you go out to visit them?
Yes. Yes.
And are there any other children in your care other than this 12-year-old?
Yeah.
Do you have children that you babysit other than the 12-year-old?
Yeah.
All right, thank you so much for coming in. All right, any other witnesses?
Oh, yeah.
All right, Mr. Ruiz. All right, the court will hear argument. Defense, any other argument?
Because the only thing is that we ask the court to consider putting on bond. Usually when somebody comes in, usually the bond is doubled. That's what we're asking the court, so case of 80,000, bond of 80,000.
All right, request for bond is denied. I'll see you all back on April 3rd for jury trial.
All
right, thank you.
We don't have a bond set at all?
No.
Not any amount.
No. And we're off the record, but Mr. Ruiz, while you're on bond, and I don't take any of these cases as true, but while you were on bond for aggravated assault with a deadly weapon, you then are charged with assault of a peace officer, another assault with a peace officer, and retaliation. And also a retaliation. So there will be no bond set in this case.
Thank you, Judge, maybe excuse.
Yes. Thank you. Corwin Campbell. Good morning. You always dress appropriately for court. Thank you so much. So what is happening? Today is the plea deadline date. So where are we?
The state has made an offer and Mr. Corwin Campbell has rejected it.
All right.
There are unfortunately still outstanding discovery questions.
What is the outstanding discovery? Who's the
Well, one, we have
prosecutor?
not received the incident detail report yet, which is lists all the time when the 911 call.
All right. I know what an incident detail report is, counsel.
Also, the state has told me that he would provide me the details, the
Who's the
report.
prosecutor you've been
Mr.
confirmed?
Garrison.
All right, just give us a moment. We'll take this up when he comes back.
Okay, I didn't know.
Thank you. Israel Elizondo. Israel Elizondo. Good morning. All right, so today is plea deadline date. What's happening?
Judge, we have reviewed the evidence, we have talked to the state. I have given my offer to the client, he's considered it. And at this time, we would like a trial setting, Judge. My client would like to exercise his right to a trial by jury.
All right, your plea deadline date has expired. The court will not accept any plea bargaining agreements in this case without good cause. How long are we expecting this trial to last?
3 days, Your Honor.
That sounds about right, Judge.
All right, Ms. Ferguson, I need a jury trial date. It's family violence, and I need an acknowledgement of discovery done before parties leave.
Okay.
All right, your jury trial date will be May 23rd
That works for me.
at 9 a.m.
Thank you, Judge.
All right, thank you. You're welcome.
We changed your vase, Judge.
Oh, well, let me just tell you what ended up
What
happening. We are allergic to the stargazers, like extremely allergic. I already knew I was, but
They are an aggressive flower.
they are.
I think it smells nice, but it's the whole house when someone gives you those.
Yeah.
It's the whole.
But they're so beautiful, but
They are beautiful.
they're aggressive in a beautiful way.
Yes, yes.
All right,
Suppose I didn't say that.
Daniel Bell. All right, what is happening with this case?
Good morning, Judge.
Good morning.
I spoke to the prosecutor, Mrs. Sorensen, at our last setting. They had not made contact with the victim yet, so we were given additional time for discovery and for the plea bargain to be offered. They're still requesting a little bit more time to reach out to that victim. It's my understanding the victim coordinator has reached out today or attempted to reach out. Mr. Sorensen.
Jordan's. Judge, I'm not aware of really what's going on. but
Yes.
We can contact the complainant immediately. I think we are having a Laura reach out right.
Okay, why were you late for court?
My ride was actually like, man.
No, here's the thing, your ride is not late, you're late,
Yes, ma'am, my fault.
so don't be late for court, okay?
Yes, ma'am.
All right, Ms. Ferguson. I want this recalled at the end of March.
March 30th.
All right, so we're coming back on March 30th. And on March 30th, state, you need to have contacted the complaining witnesses. That's what's outstanding. And an offer needs to be tendered at that date. And then it's going to be a quick turnaround for a plea deadline date.
Yes, Judge, if I could make the court also just aware, I've tried to download the videos in this case multiple times. The DA is popping them over to a flash drive.
Okay.
There's about 70 videos that need to be watched before that trial setting. Should we go that route? So I just wanted to make that court aware that I may not be ready if it's a quick turnaround for March 30th based on the amount of videos that need to be reviewed, but we will come back again in March.
All right, thank you. Ms. Ferguson will give you a reset form. Thanks for dressing appropriately for court. Even though you were late, you dressed appropriately. All right, you're welcome. Shaw Branch.
For present, Judge.
Mr. Branch, come forward.
Okay, actually, yeah.
Yes, he's here.
January.
All right, the last time we were here, states you wanted to check on some more potential cases, I believe.
There was a cell phone download, Your Honor, and it contained what appeared to be sexual material, and we needed to verify that it was not a child involved, and we were able to do that. And so I gave a copy to defense counsel.
Just received the DVD this morning.
Okay. All right, Ms. Ferguson, on Sean Branch, if we can bring this back at the beginning of April.
I did it April 4th.
All right, on April 4th, the state will be prepared to make you an offer. And then after that date, I will give you a pre-deadline date.
Okay, thank you, Judge.
All right, any questions, Mr. Branch?
No, ma'am.
All right, thank you.
Yes, ma'am. Move along. It's gonna be in the future.
Jennifer Sutter.
Your Honor, compliance.
All right, thank you. Yes. Thank you. All right, so this is what we're gonna do. I'm gonna want her to continue to be monitored because I see that the expiration date is June. So you're gonna continue to be monitored. Make sure that there are no slip ups, you understand? And whatever you need to do in order to remain clean and sober and what has been helping you to remain clean and sober, you need to continue with that. All right. Anything else, probation?
Your Honor, I do want to add that she submitted a UA today and it is negative.
Thank you. I love when people submit UAs and they're negative.
18 months.
Oh, congratulations. I don't think people realize how hard of work that is. And I did a lot of work with all the treatment courts, and so I realize how hard it is. So I'm very proud of you. All right. Is there anything else you need from the court?
So I don't have to be there.
Well, I mean, drug court, there's still a wait list. Obviously, drug court is designed to help people remain clean and sober. So it appears that you have the tools you need and you know what you need to do in order to remain clean and sober. So you need to continue doing what you're doing and do not go out celebrating. Just whatever you've been doing. I see that you've been doing your sober meetings. Continue to do those. Don't say, oh, well, there's this event going on. I'm gonna go to that and I'll just catch on my sober meetings later. Don't do that, okay?
Your Honor, we did speak and I did tell Ms. Sutter, if there's any need for any type of treatment to let us know. And she says right now, she thinks she has everything under control. And I just, emphasize that, communication right now is key for her in order to be done with our probation successfully.
All right. Because if you want to be done in June, you got to keep pushing, okay? All right, and just stay in contact with probation. I think Ms. Abrams will tell you in this court, I want people to be successful on probation. And in order to do that, communication, it really is key. And if there's something that you don't understand, or if there's something you feel that you need, ask your probation officer. If you feel you're not getting a response, just come to court. We're here Monday through Friday. Okay? All right, congratulations. You're welcome. Sorry. Christian Segovia.
I'm present. Can I just?
Sure. Yes. Well, not without your pen.
Yes,
I don't
I'm sorry.
recognize-
So I was dealing with this Jason who had to go across the hall.
Jason 2.0,
And then I'm now very kindly, this Jason is very kindly giving me a little.
Jason
time.
1.0.
Jason 1.0. And so he's gonna take a look at it. In the meantime, could I just jet to the 186 for an announcement? And then I'll
Yes.
come right back.
Yes, although we're taking our break at noon because we have jury trial starting up.
Completely understand.
All right, thank you.
Hopefully I'll have an answer. Thank
Okay,
you, Jen.
sure. Elijah Preston,
That's fine.
thank you. You've been waiting patiently.
Very good witness.
Yeah. All right, have you talked to the state about
Talk to the
this?
state, they know what's going on. Which
Okay.
one- So, Judge, we had talked to the state last week about this,
Mhm.
and then I'd gone into your office.
Yes.
with their permission, and so this is the situation where the couple thought that the protective order was the no contact order. And that was non-suited.
Yes, is this the military personnel or no? Okay, this is a different one.
It's a young, very young couple. I don't know if we want to keep the no contact order in, but they, because the protective order had been non-suited and dropped, they thought that the conditions were part of it. Just asking the court to consider removing the judge's warrant.
Okay. And state?
Your Honor, I have not reviewed the facts, but it's my understanding this was not assaultive situation.
You know, and there's no allegation of assault.
Right, do you, state and defense, I take everyone as officers of the court, I believe you. But I always, I always like to dot i's and cross t's. State, can you both maybe reach out to the complainant?
Sure.
Just so you can inform the court if there are any issues.
Okay, and Judge, I do have an affidavit that you were supposed to.
Yes. And
I know that they're requesting to have contact. I don't know if we want to go that far, Judge, but I know at this point, they're just
Yes.
asking the court to remove the judge's warrant.
no, and state, if you'll speak with the complainant, and then of course, we'll take that up today.
Okay.
Thank you.
Thank you. All right, the cases I have before me now, and I know we're waiting for one of the Jasons on Corin Campbell. Charles Garley. I had Charles Carley up here for some reason.
Step outside, so we can talk about.
Yes. Yes,
Yeah, Your Honor,
yes.
He was able to speak with his fiance. We're just waiting for the paperwork and we'll get the plea.
Okay.
It was mentioned. Oh,
Okay, great, thank you. All right, and that one's a plea. Yes. And I'm going to take, everyone, I'm going to take a 2-minute break. Sure. You're welcome.
Hold on. Hold on. Just waiting for him to get off.
Yeah, so if you go into the back offices. No, it's, I mean, it smells beautiful, but I tell you what, Warburton was,
It's gonna be just that.
I will take.
You know,
But I think they brighten up the office when you. I'm gonna deal with it. But if my face swells up, you all need to say, you gotta stop. But I will tell you, Warburton was right when she said, those flowers are very aggressive. But you know what? We could probably use that for that sewage smell, although it'll probably just smell like fragrant sewage. I don't know.
It was like from one day to the next though that it's that loud, like.
Mhm.
It was like, okay, yesterday, but then today it was like, damn.
You know, I think the flowers became loud because we didn't acknowledge them. But yeah. Whoa. But I took my allergy medicine today. Attorney Corby, is it hot in here? No, no, you're not. I always ask that question. No, the AC in this courtroom does not work.
It's not bad. I was just telling Brittany, it's not bad in here. I was in another court, it was like a sauna, so I'm still recovering from that. And
Well,
I'm
you know,
scared.
there's something wrong with the thermostats in this entire building, because you go to some courts, they say they need electric blankets. It's freezing.
I like this one.
Oh, I do too.
So this one's actually pleasant.
When I was younger, I did not like the freezing ports. Now that I'm older, it's like, I need some AC.
Yeah.
Mark, just wait. Just wait for your.
Another part we can't talk to because she has the psych out, so yeah.
Mona, are you coming to call? Oh, I didn't see the. Okay. Okay, please.
James Brooks.
I'm here on that case, Judge. So that case is set for March the 6th in this honorable court. I did receive notice that she does have a mental health court staffing admission date for March 8th.
Okay.
So I was, in the interest of saving time, I would hate for us to come here on March 6th and say, well, we're not gonna know anything until after March 8th.
All right, is your client on bond?
Yes, he's on bond and compliant. He's not here, but
Oh, so it's not on docket today.
it's on docket.
All right, Ms. Ferguson, on James Brooks, can I get a date for him after March 6th? So state, I don't know if you all are in charge of livestock cases. It's cause number 2022 CR 8814. That's gonna be removed from the March 6th date. What date, Ms. Ferguson?
I can do March 9th or the 20th.
All right, we're gonna come back on March 9th.
March 9th. And I will inform the courts of the mental health courts, Judge Martell's decision of whether he's gonna be eliminated or not.
All right, thank you.
Thank you.
Is this on? Okay.
It's a mental health pretrial liberation. It's a livestock case.
Brandon Cardona,
Good morning, Judge.
good morning. Where on the PTD?
I'll just say.
Your Honor, the PD was submitted, it was denied. We have tendered a new offer to council today.
And after discussing that with my client, Judge, he is in favor of accepting the offer. And I'd just like to set this for at least sometime next week. If that's
Oh, we can do it today.
if there's time.
Yes,
Yeah.
all right. All right, this is gonna be a plea. Oh, and this one's, so this is a plea. This one's done. Who's here on Arthur Tobar? All right, in probation, in each of these cases, there is no application. Court is calling 2022 CR 9936A and 2022 CR 10133, State of Texas versus Arthur Tovar. Could I have parties announced for the record for the state?
Debbie Cruz on behalf of the state, Your Honor.
Defense?
Robert Ramirez on behalf of Mr. Tovar, Your Honor.
And are you Mr. Tovar?
Yes, ma'am.
Counsel, in each of the cause numbers, have you received all the discovery from the stating that you reviewed with your client?
I did, Your Honor. Yes, I did receive it. Discovery.
And each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Tovar, in each of the cause numbers, I'm showing you what's entitled True Bill of Indictment. Did you review those with your attorney? Did you understand them?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment
Yes, Your Honor,
in each cause number?
in both cause numbers.
Stating cause number 2022 CR 9936A. Are you proceeding on the indictment as presented?
Your Honor, we're waiving the repeater allegation.
Any objection?
No objection, Your Honor.
And in cause number 2022 CR 10133, are you proceeding on the indictment as presented?
Your Honor, we're also waiving the repeater allegation.
Any objection?
No objection.
Mr. Tovar, in each of the cause number, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am, I did.
And cause number 2022 CR 9936A, you're charged with the offense of fraudulent use or possession of identifying information, 5 or less elderly. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. And cause number 2022 CR 10133, you're charged with the offense of evading arrest detention with a vehicle. That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am, I did.
And each of the cause numbers, if you have a plea bargaining agreement, the court does not have to follow your plea. If for any reason the court does not follow your plea, gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand? Did you understand by entering the plea bargaining agreement in each of these cause numbers, you were giving up those rights?
Yes, I did.
And did you intend to give up those rights and enter into pleas in each of these cause numbers?
Yes, ma'am, I did.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Tovar, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen?
Yes, I am.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain page. Did you review those with your attorney? Did you understand them?
Yes, we did. Yes, I do.
2022 CR 9936A. The plea bargain agreement is for 1 year in the state jail facility. There are no applications. And cause number 2022 CR 10133. According to the plea bargaining agreement, punishments be assessed at 3 years in the prison. There are no applications. They will take in consideration NIMAG number 697746 2022 CR 9935. And I'm assuming that these two cause numbers were run concurrently. Is that your understanding of the plea?
Yes, ma'am, it is.
Defense,
Yes, Your Honor.
state?
Yes, Your Honor.
Each of the cause numbers, I'm showing you the waiver appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
None.
Then in cause number 2022 CR 9936A, how do you plead? Guilty, not guilty, or no contest?
No contest.
In cause number 2022 CR 10133, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's pleas.
Your Honor, at this time, the state introduces state's exhibit number 1 and all of its attachments.
No objection.
All right, state, you may be excused.
May I approach, Your Honor?
Yes. Mr. Tobar, in each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Ma'am.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, in each of the cause numbers, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause numbers. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. We ask that you follow the plea agreement and give also assess credit for client's time served. I believe it's 111 days in the state jail case and 109 in the felony case.
In cause number 2022 CR 9936A, the court will sentence you to 1 year in the state jail facility, give you credit for any time served. This will run concurrent with 2022 CR 10133 and cause number 2022 CR 10133. The court will sentence you to 3 years in the prison, give you credit for any time served, take in consideration night mag number 697746. County Court, I'm sorry, cause number 2022 CR 9935. This will run concurrent with 2022 CR 9936A. Give you credit for any time served. Anything else with regards to sentencing? Mr. Tobar, on each of the cause numbers, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney to understand it, and did you sign it?
Yes, ma'am, I did.
And each of the cause numbers, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And each of the cause numbers, because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, Mr. Tobar, how old are you? We're off the record.
49 years old now.
You're gonna have to start making better decisions. If you have a drug or alcohol problem, there are plenty of places that are available to help you. People want to help you, but nobody can help you if you don't want to help yourself. Do you understand?
I understand, ma'am. That's gonna be pretty lenient, and yeah, you're right. You gotta stop.
All right, and you need to stop associating with people who don't have your best interests at heart. And people who are doing illegal activity, they really don't have your best interests at heart. All right, good luck to you.
Thank you.
You're welcome. Have a good day.
Let me know, maybe excuse me.
Yes, thank you.
Very narrow.
Yeah, that one is.
Are we ready on to Preston?
I don't know that we've got a response to it.
Okay, just let me know when you have your response and we'll take it up.
I'll check with Brittany.
All right, thank you. Christian Segovia.
I have not heard from Jason Montgomery.
Okay,
So,
and is your client in custody?
he is, would you like to recall this maybe like next week? And maybe we can like.
Are you all able to confer off docket?
Yes.
Okay. All right, Mr. Segovia. If you'll come down.
Maybe next Friday, Judge, would that be possible?
Not on a Friday. It will probably be a Thursday or somewhere along that line. Ms. Ferguson, can we recall Mr. Segovia for next week? Are we able to call him maybe on a Monday?
Here's my problem. I'm able to trial on the 186 on Monday. But I probably, if Thursday's okay with the board, that I don't anticipate that trial going longer than 3 days.
All right, I'm not going to be here on Thursday.
Okay. The following Monday,
Monday is spring break,
looky there.
and I'm allowing staff and everybody to be with their children, because how many times are you going to have spring break with your children before they no longer want to do spring break with you?
Okay.
We could do it the week of the 20th, and if you want to come in before then.
You know what? I actually have a vacation letter on file for the week of the 20th, but if you would like to set it then, and then let me confer, and then with Jason, and then maybe we can get it worked out and come back.
Well, if you want, then we can put it the week of the 27th. All right, Ms. Ferguson, can we recall Mr. Segovia for the week of March 27th?
Yes, ma'am, I can do the 28th.
That's fine.
All right, so we'll be back on March 28th.
That would be great. And if we can get it worked out sooner, we will contact Norma and try and work that out.
All right, thank you.
Okay, thank you, Judge.
And then Corwin Campbell. And where are the parties on Wickerson? Oh, Campbell, come forward. All right, so what's happening?
So we're waiting for Jason.
Okay, all right. All right, as soon as he comes back, we'll take it up.
Just go to support, I just turned in work for Mr. Garley. He was waiting for them this morning.
Yes.
After that.
Okay, all right, thank you so much.
Approach on this important. Goes Flores, Jason Flores.
Joseph Anzadua. Hello.
Good morning, Judge.
Good morning. Why were you late today?
That's a car issue.
All right, you cannot be late for court, you understand?
Yes, I understand.
All right,
Won't happen again.
all right, so what is happening with this case?
Judge, we are reaching out to the complainant. That is what I emailed our victim advocate about 20 minutes ago. I'm also trying to reach out to the intake attorney for family violence. There is a case that is awaiting indictment. We never got a response to what the update was, so I emailed them as well to reach out and tell them, hey, second time we've kind of rolled around on this.
Yes, because today was the day the state was to make an offer. And I saw from December, he had pending cases. One was the burglary of the habitation, which the court is in receipt of, so I'm assuming that's the case. And the other is the family violence case from December.
Yes, Judge.
So, counsel, do you have all the discovery?
I believe we do, Judge.
All right, so I'm going to give you all a 30-day reset. This is going to be the last reset for what's happening on other cases.
Understood, Judge.
All right.
Thank you, Judge.
All right, Ms. Fergus, can I have a 30-day reset on Joseph Anzadua, please?
I can do April 4th, Judge.
All right, we'll be back on April 4th.
Thank
Just
you.
get the reset form, then you're excused. Thank you. Okay, the flowers are now gone, but they're very aggressive.
They're very aggressive.
See, I'm usually the rose person.
To the right, to the right.
Jason Flores. All right, what is happening with this case?
Judge, state's asking for more time. We're just gonna be bringing in the officers who are involved in this case to talk with them and see kind of from the perspective what happened. And then we'll make a decision on how to proceed from there.
Okay. All right, so we'll put this on the same date.
Fantastic. Judge.
All right, Ms. Ferguson on Flores, April 3rd, I believe. 4th. All right, April 4th. All right, thanks for dressing appropriately for court. Thank you. And Norma, we're gonna take our break at noon, so anything that's left, they're gonna have to come back on Monday.
Yes, ma'am.
Who's here on Charles Garley? Thank you. Court is calling 2021 CR 7282, State of Texas versus Charles Garley. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Mario Moreno for the defendant.
Are you Mr. Garley? Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garley, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Just a minute. I'm searching for the indictment. Oh, that's okay. Oh, you know what? I found it. Thank you. No, I knew you had. You're always awesome. Mr. Garley, I'm gonna show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're waiving count 1, proceeding on count 2.
Any objection?
No objection.
Mr. Garley, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of assault on a peace officer or judge causing bodily injury? As a second-degree felony, the range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Garley, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, there's a $300 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 2 years. There be 100 hours community service restitution, no contact with Gabriel Ortelajo, Artalejo, and Aaron Dial, Dial, and anger management. Did you understand those are recommendations from the state? And the court does not have to follow those recommendations. Then to the offenses charged in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Your Honor, state all overstates Exhibit 1 and all attachments.
No objection.
All right, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review this document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? All right, the state, you may be excused. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court would defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Not at this time.
Mr. Garley, are you still with the person who's listed as your girlfriend in here? All right, so what steps have you all taken to handle your, I don't want to say disagreements, but your discussions differently?
At this moment, we have no discussion. The only issue was, I'm being charged with.
No, I'm talking about the facts of this case. The police came to your door, not because, hey, we're just walking around. This is like a door we should knock on. I've read in the police report that there was some issue and you wanted her to leave. So she's calling her family saying, I'm leaving. So what I've discovered in my time on the planet is whatever problems that people have in their relationships, when they don't unpack that suitcase and address it, it's still there. It's just waiting to come up whenever it wants to come up. So whatever discussion you all were having at that apartment where you told her you didn't want her there anymore, you wanted her to leave, unless you all have addressed that issue, it is still there, waiting to be unpacked. And it's going to be unpacked while you're on probation. And when you're on probation, you're looking at potentially 20 years in the prison if that suitcase is unpacked improperly. Do you understand?
At this time, there's no issues. So.
So how many children do you have? What are their ages?
16 months and one on the way. 2 months, in April.
And it's never great when a couple gets in an argument and then people are calling their family members over, because then that caused confusion. And I read in the report where then her brother's coming over, these other family members are coming over. That's not a good situation to be in. So how are you all addressing your issues? I can't order marriage counseling because I don't have any jurisdiction over her. But how are you all addressing your disagreements?
All I can say is that everything's fine and there's no more disagreements.
Oh, there's disagreements in every relationships. I don't care how people say their relationship is great. Even I'm sure Cinderella and the prince that she ended up with have disagreements. Maybe the mice are tracking in dirt or something. But every relationship people have disagreements. How are you handling those other than the police having to be called or her family members having to be called?
We just talk to each other better. Talk to each other better, I guess.
All right. Are you employed?
Yes, ma'am.
What do you do?
I handle quality and logistics for a box plant.
I'm sorry, what?
I handle quality and logistics for a box plant.
Okay. And what does that mean?
I handle the quality of different fibers for material to make boxes.
Boxes of, you mean just?
Coordinated boxes.
Oh, okay. I'm gonna need to talk to you. My boxes are always breaking down. I'm assuming you're not the person who put the stamp on that box. That's somebody else.
Quality.
Okay, that's awesome. And what are your hours like?
I work 7 p.m. to 7 a.m.
Oh, wow. That's the night shift. All right, this is what the court is going to do. $300 fine, probated, 2 years deferred adjudication, 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that, but if you do, 40 of those hours will be waived. I'm going to ask for parenting classes, and the remaining of those hours will be waived. Anger management, regular reporting by Zoom or in person, proof of employment within 30 days, no employment as a home health care provider or with minors, regular UAs, and we'll do field visits for 2 months. Probation, if there are no issues with field visits, then field visits can be discontinued. Probation, is there anything else he needs? I'm sorry, and also no contact with Gabriel Artalejo or an Arundel. Is there anything else you need from the court to be successful? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, because I'm sorry, I have notes over here that I'm looking at. All right, in this court, communication is key. You want to be successful on probation, stay in contact with your probation officer. If there's any issue about something you feel you're not receiving or communication is not being answered, we're always here in court. You can come by. All right, good luck to you.
Thank you.
Here you go. All right, Norma. So on these,
Some of them are asking, you know, when you come back, because I'm not too strict.
oh no,
And so I'm gonna put-
tell them to do the pleas. We're going to take our lunch break. And then we'll take up the matter of the pleas before the jury comes in.
So at 1 o'clock, or what time do you want them here?
They need to be here exactly at 1.
We'll be here, Judge.
All right. And then also, we can also check if these pleas are for to-do offers, we can also coordinate it with Miguel Nahara, because they'll take the pleas.
The state requested to ask you about Ronald Rodriguez on today's docket. We did receive an offer. You want to take it or Monday? He wants to take it, Judge. You want us to do that today as well?
Yes.
Okay, I'll go ahead.
And we just have one more plea to do, and then we're done. Who's here on Cara Clark?
Speak on.
Thank you. Court is calling 2021 CR 2960, State of Texas versus Cara Clark. Can our parties announce for the record for the state? Defense?
Attorney Albert Osvaldo, Ms. Clark.
Oh, come forward, Ms. Clark. Oh, I understand. Are you Ms. Clark? Counsel, have you received all the discovery and did you review it with your case?
Yes, Your
You're with your client?
Yes,
You need to be on that side. Ms. Clark, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it? Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, are you proceeding on the indictment counsel, are you waiving the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, Ms. Clark, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand your charge with the offense of theft under $2,500 enhanced? As a state jail felony, the range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Sure.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Clark, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived a right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, there's a $300 fine and the state recommends deferred adjudication. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there many such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is asking you that your community supervision be for a term of 180 days. There be 120 hours of community service restitution in CATs 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offer state exhibit 1 and all attachments.
No objections, Your Honor.
Ms. Clark, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there would be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, ask that you follow the plea bargain agreement.
All right, Ms. Clark, is there a reason why you continue to steal?
I will not, Your Honor. That was 2 years ago and everything's changed since.
I mean, I know you say you will not,
I understand.
but we're here for a third theft.
I know. I realize I'm embarrassing my children and they've grown up to be really good adults. They're productive citizens and I'm an embarrassment to them and it breaks my heart. So I want to make my kids proud. Also, I've met somebody that I care very deeply for and he has a zero tolerance for this kind of behavior.
All right,
So
when you're drug tested today, where are the results going to be? And you are getting a drug test
I'm
today.
gonna tell you honestly, for marijuana, it's gonna come back positive. Anything else is gonna come back negative.
All right, so why, if you've changed your life, why are you doing marijuana? I don't understand.
Back problems. I had L3 and L4 broken.
All right, you're going to get a drug test today.
Okay,
And if it's more than marijuana, then we're going to have some issues.
okay,
So are you sticking with this just going to be marijuana?
no.
All right, what else will it be?
Meth.
All right, so marijuana, meth, what else? All right, so why are you being dishonest with the court?
Because I don't want my boyfriend to find out, he'll break up.
Well, here's the thing. Obviously you're using marijuana, your boyfriend should probably know you're using marijuana.
He has raised the point. Yes, he knows.
Yeah. And if you're with a boyfriend who cannot tell that you are on substances, then maybe that is not a good relationship. If you're in a relationship with someone and it's supposed to be a loving and caring relationship and you're being dishonest with them, then it's not a loving and caring relationship. Yeah. All right. So this is what the court is going to do. Are you employed at all?
No, I do not have a driver's license at this time. As soon as I get my court over with, I'm gonna get my driver's license. I didn't go get it because I had a warrant.
Let me just tell you, that doesn't, not having a license does not.
I can't get employment without an ID, without a standard ID.
How old are you?
51.
And you're telling me you're 51 and you have no form of identification.
That is correct.
Okay. All right. This is what the court is going to do. Court is going to sentence you to 4 years deferred adjudication. There's a $300 fine that will be probated. 120 hours of community service restitution. How do you spend your days if you don't have employment?
Cleaning, cooking. I have a couple of friends that are sick. I go by and check on them sometimes, bring them soup. They're like sick, like dying.
All right, cats 1 and 2, proof of employment within 30 days.
Okay.
There's to be no employment as a home health care provider or with minors. I'm going to want the UA hotline, and she's to be tested weekly. A TAP evaluation, follow the recommendations of TAP. If TAP recommends outpatient treatment, I wanted to start with intensive outpatient treatment. I want a referral to felony drug court. Field visits 2 times per month until she's in some program to address these drug issues. Regular reporting by Zoom or in person. There's to be no unsupervised contact with minors. So you're living with the boyfriend?
Yeah, no, I don't live with him.
Who do you live with?
I live with a friend.
Who is this friend?
His name is James. He's a friend of mine. He lets me stay on the couch and I cook and clean in exchange for.
I'm finding this all to be very suspect.
Well, he has 2 other roommates that rent out the other 2 rooms. So I just do all the.
Let me just tell you where I'm looking at this. I have somebody before me who told me they would only, well, who started with, I'm changing my life for my children. I don't want to be an embarrassment. I'm not stealing anymore. Then I'm only using marijuana and I'll be negative for everything else. Then it's no, I'm going to be positive for meth. And I didn't tell you because I didn't want this new boyfriend to know. Then I'm living with some other guy on his couch. And there are other random people in the house.
And ma'am, it's a mother and son that rent out the other 2 rooms.
And mother and son gonna have probation come visiting that house because I think there are other things going on. So you're gonna provide, before you leave here today, you're gonna provide probation with a physical address and you're gonna make sure you're there. Do you understand?
Yes.
And who all is in that house? Are there any children in that home?
No, everybody's over 18. It's a mother, a son, and then the homeowner.
All right. Probation, is there anything else she needs? Anything else you need from the court? All right.
Just judge, just one thing in terms of the employment, I think it was proof of employment within 30 days. And is that some assistance that probation can help with,
Yes.
making it mandatory for 30 days, want to make sure that they help her?
Yes, I mean, there's employment available for everybody. It's just you got to knock your pride aside and say, I am out here getting employment so that I can meet my own basic needs. Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal, and we'll recall the warrant. Thank you. All right, good luck to you. All right, the court is on recess.
Go have a seat.
Court's on recess. Nobody's here. We're on lunch.